lines are muted. This helps us improve the sound quality. If you do have a question, you can type it into the question box on your panel, and we'll see those pop up, and we'll try to respond to those when appropriate. The session is going to be recorded, and the slides in the recording will be emailed out to you by the end of the week. So with that being said, let's get started. So a little bit about myself. I'm the Chief Compliance Officer and the Director of Technical Services for Multnomah Group. I basically oversee the regulatory compliance program as well as the technical services program. Sorry, I'm having a little problem with my screen here. There we go. So I joined Multnomah Group in about 2012. Prior to that, I worked in private practice with investment advisors on ERISA and also SEC and state compliance issues. And so today, I'm going to talk a little bit about the fiduciary standards under ERISA, which is very timely given that the Department of Labor recently released a proposed rule about expanding the definition of fiduciary. And we are going to touch on that, but pretty much for today's purpose, we're going to go through current standards, you know, how you determine whether you're a fiduciary, consequences of breach. You can see it on the slide here. And then we're also going to talk a little bit about how to perform governance documents that you might want to consider, the administration and oversight of your governance program, and things you can do for planning your program. So the first thing we're going to talk about today is, you know, what are the current fiduciary standards? ERISA basically has 4 duties to which retirement plan fiduciaries are supposed to follow, and basically it's the duty of loyalty, the duty of care, the duty to diversify investment options, and duty of obedience. I promise I'm not going to read verbatim off my slides, but I do want to list those things specifically, and then we're going to talk about each one individually. So the duty of loyalty is basically the overriding theme of all the fiduciary duties. Like it says here, you know, you have to operate the plan solely in the best interest of your participants. And the plan is for the exclusive purpose of providing benefits and defraying reasonable expenses. The plan shouldn't pay excessive compensation to investment and service providers. If you're not already familiar, that's the rule 408B2, where you're supposed to determine the services that you're being provided and ensure that the fees that are being provided or fees that are being paid are reasonable for the services that are actually being provided. You don't want to act in a manner that gives rise to conflicts of interest. That's what the new fiduciary rule covers, and again, we'll talk about that in a few slides. But prohibited transactions are kind of the current standard for that, and so some of those prohibited transactions are, you know, don't transfer or use the plan assets for the benefit of the plan fiduciary or any party in interest. So you don't want to use plan assets for anybody except in the best interest of those participants. Another conflict of interest is when you sell, exchange, or lease property between a plan and a party in interest. Lending money, and lending money is actually one of the prohibited transaction exemptions. I'll get to that in a second. But basically, parties in interest are the plan fiduciaries, service providers, officers and directors, you know, people that are responsible for overseeing the plan. There are some limited prohibited transactions, prohibited transaction exemptions. For example, making plan loans to participants. So, you know, we said earlier that lending money was a prohibited transaction, but there's a specific exemption that allows you to lend money to participants under the plan. And as I mentioned at the very beginning, the duty of loyalty is kind of the overriding theme of all the fiduciary duties. The next duty we're going to talk about is the duty of care, and fiduciaries are required to act with the same care, prudence, and skill and diligence that a knowledgeable person would use. Fiduciaries don't have to be experts with all aspects of the plan management, but compliance with the standard, it may require that you actually hire experts when you yourself are not an expert in a particular area. And like it lists here, attorneys, accountants, consultants, investment managers. If you don't have the expertise in that particular area, you would want to make sure that you obtained that expertise. One thing, I guess, that I would keep in mind on this is fiduciaries are not absolved of their liability simply because those delegations, those functions have been delegated. You would still have the duty to oversee the selection and the monitoring of those experts. So you can't just hire somebody and wash your hands of it. You have to oversee the expert and make sure that they're doing their job. And it's known as the Prudent Expert Standard. The standard's objective, and it's based how a person with experience and knowledge would act in a certain situation. If they lack the expertise, they need to obtain help. And I think the most important is this is a flexible and evolving standard of care. It's not a black and white issue. It's always evolving given what's going on in the times. For example, the fee, plan fees are a big issue right now going on where, you know, the fiduciary standard is a little bit murky. So there's also a duty to diversify investment options. And so you want to offer a broad range of options to participants. Those options should have different risk and return characteristics depending on you know, what your participants are looking for. Some might be looking for something lower risk and they're willing to accept a lower return. Some might, you know, maybe younger participants might be looking for something they're willing to accept a little bit higher risk in return for higher returns. And then as a fiduciary, you evaluate, select, and you also monitor the plan investment options, and you should have a documented diligence process. And we'll talk about documentation a little bit later in the presentation. The duty to diversify investment options is very much related to the 408B2, the fee reasonableness. You know, one of the things that are kind of a hot button issue right now is that sponsors should be looking at the investments that they have in their plan and making sure that the fees that are paid on those investments are not excessive. And the duty of obedience. So you're required to act in accordance with the plan documents to the extent that the plan documents are in compliance with ERISA. A good example of that is recently we've had the Windsor decision that affects you know, the federal rule on, you know, who is a spouse. And if your plan documents, for example, say, you know, husband or wife, that would not necessarily be in compliance with ERISA any longer. And so that's a situation where you would want to speak with your counsel to amend your plan documents so that the document is in compliance with ERISA, because you are required to administer your plan in compliance with ERISA. Which is a good point that, you know, the fiduciary needs to know what the ERISA requirements are, or they need to make sure that they hire somebody who can help them know what those requirements are so that they can be in compliance with them. The plan document is basically the employer's manual for operating and administering the plan. So you want to have a plan document that is in compliance so that when you are adhering to that document, you know that you are also in compliance. And in addition to compliance with ERISA, the plan document needs to be in compliance with the Internal Revenue Code and any other applicable laws and regulations. The reason this is so important is deviation from the plan document provisions would typically constitute a fiduciary breach. And one of the things that kind of trips up plan sponsors often is you want to administer the document consistently, regardless of sympathetic circumstances. So if you have, for example, hardship provisions in your plan document and you use the safe harbor definition, you know, those are the only things that would constitute a hardship. And a participant may have very sympathetic circumstances that fall outside of that, and you may want to let them utilize a hardship option, but that's what the point of this last bullet is, you know, regardless of the circumstances, you want to administer the plan in compliance with the provisions. So we've talked about the fiduciary duties. So the question is, who is a fiduciary and who is not a fiduciary? Well, anybody specifically named in the plan document is a fiduciary. For example, this might be the employer, a board of directors or a board of trustees, a retirement plan committee if those duties have been delegated, people performing discretionary functions on behalf of the plan. By discretionary, it's the decision-making functions. Anybody who's exercising control over the plan assets. A 338 investment manager would be considered a fiduciary because they would have the ability to choose the investments in the plan and swap investments in or out of the plan. Any person rendering investment advice in exchange for a fee or other compensation, as it stands right now, an RIA, a registered investment advisor, is a fiduciary, not only under the SEC rules, but because the investment advisor is the person that's providing investment advice for a fee. And that's whether or not the advice is discretionary. The advice could be non-discretionary, and they're still giving advice for a fee, even though they don't have the authority to implement it or say yes or no to whatever the recommendation is. Finally, any person who accepts fiduciary responsibility in a service contract. If they agree that they're going to be a fiduciary, then they're considered a fiduciary. The types of fiduciaries are appointing fiduciaries. Those are often the board of directors or the board of trustees is a good example of an appointing fiduciary. They're the employer. They're the person who's, you know, overridingly responsible for the acting as a fiduciary to the plan, but you know the board of directors is not going to you know, meet all the time to talk about just the retirement plan. So they often delegate those duties to a retirement plan committee, and we're going to talk about delegation in a few slides. There's also limited purpose fiduciaries, and those are appointed and monitored by the named fiduciaries. And again, that can be the board of directors. If the board of directors has delegated that authority to a retirement plan committee, for example, to hire a consultant to provide investment advice, then the appointing fiduciary is the retirement plan committee, and the limited purpose fiduciary is, for example, in this situation, the consultant. They are limited. They are a limited fiduciary in the sense that they are hired to provide investment advice. So they're a fiduciary in terms of investment advice, but it doesn't make them a general fiduciary to the plan. So who is not a fiduciary currently? Currently, you know, activities related to the plan, settlor activities. So the decision to actually provide a retirement plan, that is a settlor activity. And those aren't restrained by ERISA's fiduciary responsibilities. They can be made based on a company's business interests, you know, and when they're designing the plan, you know, whether or not to, you know, how much of a match we're going to make. All those initial decisions are settlor decisions. So establishing a plan and choosing plan designs and plan features, if the decision is going to be made to amend or terminate a plan. One thing to keep in mind that if the plan document designates a committee as the responsible fiduciary, you know, there's an argument that the establishment of the fiduciary committee is a settlor function and not a fiduciary function. And it gets a little bit splitting hairs. So establishing a committee versus if it's in the plan document that a committee will oversee the plan, that may be a settlor function. But then the acts that those committees take once the plan is established would be fiduciary functions. In addition to settlor activities, people performing, quote, ministerial or administrative services of the plan, but without discretionary authority. So, for example, the people in payroll that, you know, if somebody signs up for the plan, the people in payroll, they're, you know, taking the money out of the check. You know, they're entering it into the computer to have that deduction made. They're not going to be considered a fiduciary just by virtue of processing the enrollment documents. If you provide the services within the policies and procedures, you know, that the decisions that are made by other people, if you administer those decisions, that's generally not going to constitute a fiduciary activity. And finally, attorneys, actuaries, accountants, record keepers, generally they're not going to be considered fiduciaries if they don't specifically accept fiduciary responsibility. But for example, record keepers often might accept a limited purpose fiduciary under ERISA 316, you know, to administer certain functions of the plan, like to process loans or hardships or quadros. You know, they might actually accept that fiduciary duty to make those decisions. So how do you determine whether you're a fiduciary? Well, there's the things we just talked about who is and who is not a fiduciary. Those are pretty specific. But there's also a functional test. And this is actually an important piece of the new Department of Labor definition of fiduciary. You don't have to have the title of I'm a fiduciary necessarily. It's possible to be a de facto fiduciary, you know, a fiduciary to the extent that you're actually performing those functions. So you can call yourself Purple Seal if you want, but if you are administering the plan document and making decisions on who can enroll and who can't, you're going to be considered a fiduciary to the extent you're performing those fiduciary functions regardless of what your title is. Some of the responsibilities that may present fiduciary implication, you know, following the plan document provisions. So I know it's a little nuanced to kind of splitting hairs following the document provisions, but for example, an example would be making a determination of eligibility to participate in the plan, enforcing the vesting schedule, and loan distribution and eligibility determinations. If you are the one deciding those things versus just administering those things, you know, under ERISA, it's important for participants to have certain information about the plan. As a fiduciary, you have to ensure that that information is provided, information about the plan and information about the investments. As an employer, it's a fiduciary responsibility to make sure that contributions are remitted in a timely manner. There are certain rules about, you know, the time frame that you have to make those contributions once you take the money out of the employee's check. Employers must have a fidelity bond, and that's really important. That a lot of plan sponsors get tripped up on the difference between a fidelity bond and fiduciary liability insurance, and that's something we'll talk about in a few minutes as well. It's a fiduciary decision to hire service providers. You know, again, if you're going to hire a record keeper, it's going to be a fiduciary duty that you oversee that record keeper and that you hire a record keeper where the fees being paid are consistent with the services being rendered. Again, that kind of goes to that 408B2 rule. You have to ensure the reasonableness of the fees in light of the services being provided. It's a fiduciary action to select and monitor the performance of available investment options. That is something that you can either hire a non-discretionary investment advisor to give you recommendations, or you can delegate your fiduciary duty to the investment advisor and let them make all the decisions on the investment options to put in the plan, and then making the decisions that are required to comply with law. One of the reasons all of this stuff is so very important is because what happens if you breach your fiduciary duty? Well, under ERISA, you expose yourself to personal liability when you breach your fiduciary duty. There's obligations to restore profits. There's additional penalties. I believe the monetary penalties are can be up to 20% of the recovery amount. There's potential criminal penalties for willful violations, and then other equitable and remedial type relief. For example, just removal from your position as a fiduciary. I think the important thing for fiduciaries to understand is under ERISA, the consequence can be personal to you as the individual fiduciary. Under the Investment Advisors Act, there's consequences for breach under the Investment Advisors Act, but it's basically rescission of the contract. I mean, there's nothing that's going to go to personal liability under a claim under the Investment Advisors Act. If there is a fiduciary breach, that doesn't mean they're going to come and take your house necessarily. There's correction methods. You can go through the Department of Labor or the IRS and actually correct your mistakes, correct certain mistakes. But fiduciary breaches that remain uncorrected may give rise to financial personal liability and penalties. So one thing under ERISA is that if there's any provision in the plan document that would purport to relieve a fiduciary from their duties, it's void. You can't contract your way around ERISA responsibilities. A plan can maintain fiduciary liability insurance, and this is different than a fidelity bond. Under ERISA, a fidelity bond is required, and that kind of covers issues relating to criminal or willful activity, stealing money from the plan. The fidelity bond is meant to protect the plan in those type of circumstances. Fiduciary liability insurance covers the plan and the fiduciaries more for negligent type actions. Couple things to keep in mind that often the plan documents will already indemnify the fiduciaries when they're acting in the scope of their job. But there's generally no indemnification for willful misconduct or fraud or bad acts. If you make a mistake, your employer in the plan documents may have something written in there that already protects you. Otherwise, you can get additional liability insurance policies through a rider. And ERISA requires plans to maintain a fidelity, I mentioned this, maintain a fidelity bond for people who, quote unquote, handle plan assets. And again, handling plan assets is specific to, for example, the fiduciaries of the plan, say the board of trustees or the committee members. An investment advisor may be handling plan assets if they are a 338 manager, an investment manager with discretion. And so those people are required to be covered under the fidelity bond, which again covers things like theft, stealing from the plan. But the fiduciary liability insurance is more to cover the people doing the decision-making on the plan or the day-to-day operations in the event someone makes a mistake. So that was all kind of under the current scheme, what the fiduciary requirements are and what your responsibilities are. Just last month, the Department of Labor published their new proposed rules on the definition of fiduciary. It has to do with conflicts of interest and retirement investment advice. Under the new rule, or excuse me, the new proposed rule, everybody would be basically required to put the client's best interest first. And this is a change, for example, that would cover not just your defined investment advisors, an investment advisor, a registered investment advisor under the SEC, or a state registered investment advisor. This would cover any individual who receives compensation for providing advice. And in a broader perspective, it also covers IRAs in the proposed rule. We're not going to get into that too much. But the important piece of this is that in addition to investment advisors, this rule would cover brokers, insurance agents, and consultants that are giving investment advice. Investment education we'll talk about in a second. But under this proposed rule, they would have to provide impartial advice in the client's best interest. One of the main differences is, currently broker-dealers under FINRA regulations, they're just required that the advice be suitable, which is different than in the best interest. Suitable advice means this investment option would work for you. It may not be the best investment option, but it is a suitable investment option, and I'm going to get paid making that recommendation. So there's a big difference between suitability and best advice. So under this new proposed rule, the impartial advice must be provided in the client's best interest. Any payments creating conflicts of interest cannot be accepted unless, of course, they qualify for an exemption. That's one of the interesting points of this new rule, is that the rule that was proposed back in, I think, 2009 or 10, the old rule kind of went the same route as the way it is today. There's the conflicts of interest, and then there's been prohibited transaction exemptions that cover numerous very specific type of issues that an individual investment advisor or a broker might come upon, or a plan sponsor. This new rule is much more broad in scope. We're going to talk about the best interest contract, and basically what it does is it covers it gives specific contractual requirements, to act in the client's best interest. But it almost, in my opinion, it removes all the prohibited transaction exemptions, the need to have an individual exemption for every single thing. It gives you some kind of discretion to decide what's in the best interest. Hopefully that makes sense. One of the things that the new rule also does is that, like the old proposed rule and like the current standard, it preserves access to retirement education. So there's a big difference between investment advice and investment education. So investment advice is going to be something that's specific to, for example, an individual plan participant. You're going to go and you sit with them one-on-one and talk about their specific situation, and you say, I would recommend you invest in this, this, and this. That's going to be investment advice. General education is when a consultant or somebody comes in and they just give information that the average person should have about a mix of assets based on their age or income, etc. So they come in and they do a group education, and they say, okay, if you're in your 20s and you're just starting, somebody your age might want to invest in this type of portfolio. That's going to be considered general education, and it's not going to trigger the fiduciary duties. However, even under general education, if you make references to specific investments, that's something that would likely constitute fiduciary advice. So it's one thing to say, I recommend you invest in target date funds for your age. It's another thing to come in and say, I under you invest in Vanguard target date funds, or Fidelity target date funds, or T. Rowe Price. Under the proposed rule, references to specific investments will generally constitute investment advice. So non-fiduciary activities are also, there's an exception, or there's things that are considered non-fiduciary activities. So order taking, and sales pitches to plan fiduciaries with quote-unquote financial expertise. Order taking, for example, is I call up my broker and I say I want to buy 100 shares of Apple. I just tell the broker what I want and they process that order. That's not going to be considered investment advice. It's just when the broker starts making recommendations of where I should put stuff in my portfolio, that's going to be treated a little differently than it is under the current rule. So I mentioned this best interest contract exemption under the proposed rule. Basically, the best interest contract exemption, it's fairly similar to requirements that RIAs have currently. RIAs, registered investment advisors, under SEC and state rules. So you have to have a contract that commits the firm and the advisor to providing investment advice, or providing advice in the client's best interest. So that's going to be a contractual provision. Under the contract exemption, the firm has to adopt policies and procedures that are designed to mitigate conflicts of interest. That is a requirement that's currently under the SEC rules. Form ADV, if you look at any investment advisor's ADV, they'll give you some information about their policies and procedures and how they mitigate conflicts of interest. And this one is interesting, clearly and predominantly disclose conflicts of interest. Again, that's a nuance that's interesting between ERISA and the SEC rules. Under the SEC rules currently, that's what is provided for here. Your Form ADV, you must clearly and predominantly disclose conflict of interest. Where ERISA is right now is that you can't get out of the prohibited transactions just by disclosure. You can't just disclose and then go ahead and make the transaction. Under the prohibited transaction rules, you are simply not allowed to do it. You can't get out of trouble by disclosing it away. So that's a big change under the proposed rule. And what happens now? Well, the current proposed rule, there's a 75-day notice and comment period that started April 20th. After the notice and comment period, there's going to be a public hearing. And eventually, this may lead to a final rule. It's happened before where even after the notice and comment and the public hearing was scheduled that they yanked the prior rule, but you know, eventually this may lead to a final rule. One of the things that's interesting on this is, you know, unlike the prior proposed rule, the department has consulted with both the SEC and the Treasury as well as other regulators on forming this proposed rule, which is important because, you know, they don't want to propose a rule that's going to put you in the plan sponsor in conflict with requirements under other rules and regulations, such as, you know, the FINRA rules, the suitability rules, or the SEC's rules. So they've coordinated with those agencies to, you know, make sure that this is a rule that would work for everybody, or hopefully work for everybody. So now that we know all about our fiduciary duties, what do we do? The first part of the administration of those fiduciary duties has to do with delegation. We've talked about that a few times. So if you take a plan, whether it's a corporate plan or an education institution plan, there's typically a board of directors, or in the education setting, a board of trustees, who are the, you know, quote-unquote de facto administrator. Generally, the plan administrator, unless it's named in the document otherwise, the employer is going to be the administrator. But if the employer is a company, you know, somebody has to be in charge of this area, and it's usually the board of directors. From that point on, again, the board of directors, they have kind of bigger, you know, 50,000-foot issues to deal with. They're not going to specifically meet to discuss the retirement plan. So what they typically do is delegate their duties to a retirement plan committee. The committee members usually have decision-making authority, which is going to render them a fiduciary. The board, again, can choose to indemnify the committee members from their fiduciary liability, and that's often typical, except in the case of gross negligence or willful misconduct, fraud. The indemnification is not going to cover those sorts of issues. The complexity of the plan is going to determine the size and structure of the committee. So larger plans, they may have, I've seen plans that not only have a retirement administration committee, but they maybe have a separate investment committee, or they may have a separate settlor committee the settlor committee may, deal with the plan design issues, which are non-fiduciary functions, and then, once those decisions are made, the retirement plan administration committee is going to handle the administration of it. Smaller plans typically create one retirement plan committee. They may, for example, make suggestions to the board regarding settlor type functions, but those hats are separate, and so you need to be careful in your meetings about how those things are done. You don't want to be charged with being a fiduciary for something that you didn't realize you were treading into those waters. Committee membership, it can vary. Maybe 4 people or 10 people, depending on the size of your company. The one thing I guess to keep in mind is the larger that it gets, the harder it is to get consensus, if you will, on certain issues. How the membership is structured, you need to consider, or you may want to consider what committees will be established and maintained, whether you want, again, going back to the last slide, are you going to have an administrative committee, an investment committee, a settlor committee? Are there going to be 3 separate committees, or are they just going to be one? And who should be on the fiduciary committee? Often we see individuals from human resources, the faculty, administration representatives, or business unit representatives, often, for example, finance. And then who should be responsible for appointing the committee members and monitoring their activities? Well, we've mentioned before the board of directors or the trustees often delegate the authority to a retirement plan committee. Is the whole board of directors going to oversee that? Are they going to delegate a chairperson of the committee specifically? And often they designate committee members either in the plan document or often in a delegation document by their name or by title. Often I see people using a title to delegate functions, because then if one person, if it says Joe Smith, when Joe Smith leaves, you have to redo your documents. But if it says Director of Human Resources, if Joe Smith leaves and somebody else comes in, then that person's already authorized in the documents to be on the committee. So on the operation of the committee, you want to have documents that govern the actions. So a committee charter will, the charter from, say, the board of directors to the retirement plan committee will clarify what those committee members are allowed to do. Often it involves an investment policy statement, and the investment policy statement sets forth, what types of investments can or may not be offered into the plan. It describes how the investments are evaluated, and that's actually, it's pretty important. I've seen a lot of investment policy statements where it says, if we have a fund that's been in the bottom half for more than 2 quarters, it's going to be removed. Well, that's not something that, in our opinion, is maybe a really good idea, because if you remove it at that time, it locks in the losses. You want to look at the qualitative issues of that fund to determine, are they in the bottom quarter for a reason like there was a manager change, or are they in the bottom quarter because, they're an active manager and their whatever style is out of favor right now. However, styles are cyclical and they come back. So, if you have a requirement to remove an investment manager for performance after only 2 quarters, it could be that once you remove them, that style comes back into favor and they're outperforming from then on. So you really want to think about the structure of your investment policy statement. You want it to be, you want it to give you guidance, but not so restrictive that it's going to force you to do things that might not be in the best interest of the plan. And as important as it is to have good governance documents, it's very important to follow them. If you have documents and you don't follow them, that's going to be evidence of imprudence. So make sure that your documents reflect the actions that you want them to reflect. And if they don't, then you need to determine, do we need to change our policies and procedures, or do we need to revise the investment policy statement, for example? So the conduct of the meetings, some of the things we advise on are, having an agenda and a list of topics that you want to address. Often, you review the reports from the fund manager. Fund manager performance, the fees and expenses. You want to review the reports for legal and compliance issues, for example. Making sure that the reports that you're given cover your due diligence obligations. And then a review of maybe participant issues. Who's using the plan? Do we see any trends in enrollment processes, or is there a lot of loans that are going out or hardships for leakage? You want to review your participant issues as well, because that's going to be an indication of maybe design type changes that you would want to make, or if you see a trend going on that's either good or bad, you can deal with that. It's important to keep minutes to document the activities and confirm, procedural prudence. It's, a lot of cases right now that are out there have dealt with either not following your documents or not having documentation at all to support the decisions that you're making. So minutes are very important in the sense that it documents your procedural prudence. If you have a meeting and you decide to remove a fund manager from the plan, a specific fund from the plan, you will want to document why you're making that decision. If you don't have any documentation to that effect, then you kind of expose yourself to a claim that the decision you made wasn't prudent. And avoid the overlap of fiduciary and settler activities. We mentioned that earlier, that often people wear 2 hats. You want to keep meetings regarding those 2 functions, you want to keep those separate. So some of the documents to kind of get this process going: a committee delegation charter. We spoke about that a little bit ago, about plan committees being established by charter. It delegates the specific responsibilities that it delegates the box that they're allowed to make decisions within. So, you're allowed to, the committee's allowed to make decisions regarding A, B, C, but not X, Y, Z. Often we see you're allowed to make decisions for the general administration of the plan, but you, committee, are not allowed to make decisions that are going to affect the company's bottom line, or, you're not allowed to decide to give a 4% safe harbor match instead of a 3% non-elective match. You're not allowed to just simply make decisions that will affect how much money that the plan sponsor is going to have to pay. It indicates each committee member's specific responsibilities. So if you have committee members, one person is the chair of the committee, they have their responsibilities. If one person from the committee is on human resources, they might have their responsibilities to take back to their group, processing payroll-wise and the enrollment materials. It describes, the committee charter would describe how often the committee should meet. Often we see quarterly or semi-annually. Rarely should the committee meet less than annually, in our opinion. And how meetings will be run. How do you make the decision? If there's 5 people on the committee, do you have to have unanimous decision? Do you have to just have 3 people in favor versus 2? Who's going to keep track of the minutes? An investment policy statement, which we've also discussed briefly, again, describes the processes and procedures for the investment options that you're putting in the plan. What's the process for investment direction? Are the participants going to direct their own investments? If so, do you have an intention to comply with 404C? Are you going to designate a qualified default investment election? Internal administration and oversight. So again, you have your committee with the who have their fiduciary responsibility. They're going to delegate certain things to their internal staff. For example, HR delegating certain processes to payroll. And then the fiduciary is going to kind of oversee that function, because it's important, because the administration by internal parties, it doesn't absolve the fiduciaries of their fiduciary status. Like hiring a service provider that you need to oversee, when you delegate to staff internally, you also have to oversee that process. And so you have to monitor your internal staff. External administration and oversight, very similar. If you're going to hire a service provider to manage a particular portion of the plan, again, hiring that service provider doesn't absolve you, a fiduciary, of their liability, but if you're overseeing them and your oversight is reasonable, even if an error is made, it's going to the fiduciary, as long as they're doing the oversight that they're supposed to do, they're going to be okay. So select and monitor your external service providers carefully. And depending on the circumstances, they may or may not be fiduciaries to the plan. We spoke earlier about record keepers and processing loans. So the question is who's going to be the fiduciary in that case? Is the plan sponsor going to oversee the loans that are being processed to ensure all the documentation is okay, or is the record keeper going to be a 316 fiduciary doing those things as well? Often you'll want to look at the service contract to determine whether they've agreed to act in a fiduciary capacity, what the limitations and liabilities of that contract are. And loans and hardships, actually, we can discuss specifics, because there was actually some IRS guidance that were put out, loans and hardships, just recently. If we have time, I'll cover some of the basics on that. So adhering to ERISA standards when you discharge your fiduciary duty on limiting liability. Again, you want to follow your plan and governance documents to the extent that they're compliant with ERISA. If not, you need to get your plan and documents in compliance. You, for now, until we know anything further from the Department of Labor, you want to avoid the prohibited transactions that are out there. You want to document your decisions and actions and engage in procedural prudence. And one thing, procedural prudence is, you may want to have a compliance calendar that gives you specific dates of when things should be done. Like, when do I need to file my 5500? And, maybe every quarter I'm going to look at the loans that are being processed and make sure they're in compliance. Something like that. Have a calendar that flags you to oversee certain procedures. You want to create good plan governance. We've talked about distinguishing between fiduciary and settler functions, identifying and correcting discrepancies in plan terms. And the important thing in this is inconsistency can lead to exposure, both for named fiduciaries, for failing to monitor the fiduciaries that they may hire or oversee the service providers, and also for the functional fiduciaries. You know, they need to understand what it means to be a fiduciary. They need to understand their responsibilities. And finally, assembling your team of advisors, you know, record keepers, investment consultants, attorneys, whatever you think you need to properly administer your plan. We've kind of already went over formalizing a retirement plan committee, ensure that the committee members understand their duties, ensure the committee meets regularly and that they document their decisions and actions, develop an investment policy statement, and then in addition to the investment policy statement, part of the responsibility would be to collect and review, for example, the investment reports. Do your due diligence. Again, you can't just hire a third party to make recommendations on the investments. You would want to document that you are understanding those investments and why decisions are being made to change a fund out of the plan or maybe to leave a fund in the plan. And document the investment fee reasonableness, renegotiate your fees. You want to document that for purposes of 408B2, you know, the fees that you provide are reasonable in light of the services being rendered. That doesn't mean you have to pay the lowest fee. It just means for whatever services you're being provided that the fee you're paying is reasonable. So service provider due diligence, you want to review and understand all your vendor service agreements. You know, what are their responsibilities? We see often plan sponsors kind of tripped up on, you know, them thinking that somebody's taking responsibility for something, but really in terms with a service contract, that's not the case. Collect the information and review the investment provider information, and monitor your vendors that provide services to the plan. You know, a lot of clients I've seen that have multiple vendors that are offering very similar options. You may want to consider consolidating your vendors. And then review the vendor disclosures. So some planning for sponsors, participant communications, make sure you're providing the required documents, and then document that you're actually providing those things. Ensure compliance with applicable laws and regulations. This is a tough one for plan sponsors. This is often where it might make sense to hire a consultant, somebody who's out there that knows all the disclosure rules and regulations, and understanding new regulations that might be affecting the plan, especially, well, smaller or even mid-sized plan sponsors. They don't have somebody out there that's, you know, understanding what's going on in the retirement plan world and what new regulations are out there. So as a fiduciary, it is required of you, so either ensure that you're doing that or maybe get some help with that. And then internal controls, this goes back to the compliance calendar. You know, maybe review the timing of your contribution deposits. You don't want to find out, you know, a couple years down the road that you're not making timely contributions and having to correct that. That's something that you'll want to do as part of your procedural due diligence. Maybe a plan auditor, if an audit is even required. And I think the important thing here is assume your plan at some point will be examined by the Department of Labor or the IRS. Act like that's going to happen, and you should, that will be helpful to you at the time if it ever does occur. And then Decision strategy actions keep on file for at least 7 years, has to do with statute of limitations issues. You know, longer may be required, but the recommendation is at least, or not the recommendation, but I think the general best practice is at least 7 years. Last couple things, insurance, obtain your fidelity bonding. It's a requirement under ERISA. Consider fiduciary liability insurance. Look at the employer's own indemnification provisions. Is there indemnification provided for under the delegation docs? Is there indemnification provided for under corporate bylaws, resolutions, or even state statute? Might have, your own state statute might have statutory indemnification for certain employees. But often that's more directors and officers, so you want to confirm your administrative employees are also protected. You know, if they're not members of the board of directors or officers, you want to ensure that they're protected as well under the insurance policies. Finally, you know, consider performing an annual fiduciary audit. You know, review your board resolutions, your plan documents, review all those documents to ensure that your practice is aligned with that. If there are inconsistencies, you would want to make amendments or take corrective action. Again, you know, it goes to what is the intent of the plan sponsor. If the intent is the way the plan document is laid out, then you want to change your actions. But if the intent is not how the plan document is laid out, you might want to consider amending your plan document. So that's all for today. If you have any questions, I apologize. I don't really have a lot of time to get to the loan and hardship guidance by the IRS recently. Might say a word or two on it, but basically it goes to how kind of when an employee, for example, wants to take a hardship, they can't self-certify that hardship. The employer has responsibilities to ensure that the reason they're taking the hardship, or for example, a loan, you can't just let your employees self-certify it. You actually have to collect documentation that substantiates that it's needed. I know a lot of plan sponsors who do rely on the self-certification. The IRS, in this recent guidance, it was a, if you want to write it down, it's issue number 2015-4. It was April 1st of 2015 from the IRS newsletter that clearly stated their opinion that self-certification is not adequate and auditors are specifically looking at that issue. That's all for today. I don't know if I don't think I have any questions outstanding. Oh, wait, I do have a few questions outstanding, but I think I'm going to have to respond to those. I'll look at those and respond to them individually. I apologize I didn't get to those. Thank you very much for your time today, and if you have any questions, please feel free to contact our firm, and we will see if we can help you out. Thanks so much. Bye.